Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, listen, I was doing this video the other day and I was going through the dockets on a lot of other pending 2A cases before the United States Supreme Court. And as you know, routinely there was challenges to 18 United States Code Section 922 G1, which is the prohibition on felons possessing firearms. And I said there was at least 20 plus challenges currently before the United States Supreme Court in some form or another. Almost all of them raise the exact same issues. You read one brief, you kind of read them all. But I found this one. And this one takes a very, very unique angle. And it takes a very, very unique angle because it's rooted in constitutional principles. It's rooted in pretty solid case law. And if correct, could actually undo a whole slew of federal gun laws. I'm actually not making it up. I'll try to explain it to you so we can connect all the dots and you will understand as well. So today, let's spend a few minutes and let's talk about a new argument that could undo dozens of federal gun laws. Okay, America, had to geek out the other day, big time. Pulling up a bunch of Supreme Court cases, just figuring out what's happening in the 2A sphere, going through the litany of cases that are challenging the federal law on felons possessing firearms. And along comes this case, Williams versus United States of America. It is a petition for certiorari that comes out of the 11th Circuit. Now, it too has all the usual suspects that I read time and time and time again in all of these other briefs. However, it raises another issue, and it is a fascinating issue. I thoroughly enjoyed reading it, and I want you guys to be aware of it, because if this legal theory were to be true, and again, you will see it is rooted in constitutional principles, you will see that it has pretty solid case law to support it, then this actually does have the ability to undo a whole bunch of federal gun laws. Now, does it have the ability to undo all federal gun laws? I didn't say that. No, I did not. And it clearly and absolutely positively would not. And when you understand this issue, you will understand as well why. But to give you an idea of what the issue is as presented by the petitioners, it is as follows. Whether 18 United States Code Section 922 G1 is facially unconstitutional because it exceeds Congress's authority under the Commerce Clause and is unconstitutional as applied to Mr. Williams' intrastate possession of a firearm. Oh my God, we gotta start geeking out about a couple of other things. Yes, for you to understand this issue, let's talk about two things. First of all, let's talk about the 10th Amendment. The 10th Amendment, which many of you I know are real big fans of, reads, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states, respectively, or to the people." And so many of you always beg the question, what even gives the federal government the ability to regulate firearms? Because I do not recall any portion of the Constitution saying that the federal government gets to regulate firearms. It would appear to be one of the many, many things that were reserved to the states, right? Good argument, except then you got to understand the Commerce Clause. And what is the Commerce Clause? Well, the Commerce Clause is the big, gigantic black hole of legal authority that Congress has used since the inception of the country to regulate all sorts of industries, not just firearms, all sorts of industries. What is the Commerce Clause? The Commerce Clause refers to Article 1, Section 8, Clause 3 of the United States Constitution, which gives Congress the power to regulate commerce within foreign nations, among states, and with Indian tribes. And so whenever Congress wants to regulate any particular type of activity or industry or level of commerce, what do? They just say, well, because it probably involves interstate commerce, we get to regulate it. And that is how the federal government many years ago got their hooks into firearms and how they have continued to be there. It's through the Commerce Clause. And the whole great debate of federalism is about how much authority does the federal government truly have through the Commerce Clause. Okay, but what if, hypothetically, Congress didn't have the authority to regulate everything related to firearms? Maybe some activities, certainly the interstate commerce of firearms and things like that, but mere possession and things like that? What if? Okay, well, here's how the argument works According to the petitioners, Section 922G1 of Title 18 makes it unlawful for a convicted felon to possess in or affecting commerce any firearms or ammunition. Okay, but how does possession of a firearm have any effect whatsoever on interstate commerce, right? That's a question. Well, the problem is that way back in 1977, there was a case called United States v. Scarborough. And Scarborough found as follows. This court considered the predecessor statute to Section 922G and held that evidence that the firearm had previously traveled in interstate commerce was sufficient to satisfy the interstate commerce element. Okay, because the firearm obviously at some point was traveling in interstate commerce, that allows the federal government to regulate the activity such as possession of that item. All right. Now, that's 1977, but here's the problem. Even though everyone kind of accepted that as, okay, well, that's how they get to do it, many years after Scarborough, there was a challenge to, some of you may recall this, the federal gun-free school zones. Okay, so the federal government tried to regulate gun-free zones in and around schools. And that was codified in 18 United States Code Section 922, subsection Q. So a different subsection of the same statute. Now, in the challenge to that statute, the court found that, we need to have something more than just potentially possibly having been involved in interstate or affecting interstate commerce. What we really need to find here in order for Congress to have authority under the Commerce Clause is that it needs to substantially affect commerce. Consistent with the great weight of the case law, the proper test requires an analysis of whether the regulated activity substantially affects interstate commerce. Based on this substantially affects standard, 18 United States Code Section 922Q, which prohibits the possession of firearms in school zones, exceeds Congress's Commerce Clause authority. So ultimately, the federal school gun-free zone law was struck down because Congress did not have the authority to regulate that activity. Now, that has led the petitioners in this case to point out Section 922G1 likewise exceeds Congress's Commerce Clause authority because it does not require that the possession substantially affect interstate commerce. So, while facial challenges are usually like throwing rocks at the moon, a very effective facial challenge would be that Congress had no authority to enact the law to begin with. Now, again, I don't want you to think that this is the great life-ending meteor to all federal gun laws, because many federal gun laws absolutely positively are regulating interstate commerce, and absolutely positively, as I read the Commerce Clause, the federal government would have authority to regulate that. However, that doesn't mean all federal gun laws fall into that category. And are there portions of 18 United States Code Section 922, as well as portions of other federal gun laws that would be susceptible to this argument? There most definitely is. And that is why this argument has the potential to pick off and undo dozens of federal gun laws. Okay, the case once again is Williams versus United States of America. A. Fitzgerald Hall, the public defender, is the author of the brief and the one who came up with all of these arguments. Nice work. We're going to go ahead and link it all up down below so that you guys can geek out on it for yourself. And if you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information, it's down there in the description box. If you got an idea for a video that we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that, it's down there in the description box. And then finally, and most importantly, let's everybody remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.